Yes, good morning, Mr. Ruffin.
So I finished my submissions off first. Please, Your Honour. I was at the bottom of page 31 of the submissions, turning to the Ramsey and the Wellington District Court. In that decision, the ACC statutory framework, in the bit set out at the bottom of the page, does have a privative provision, and the terms of that are set out at the top of page 32. If a person has a right to apply for a review or appeal about a matter, the person has no other remedy in relation to the matter, whether in any court, the employment tribunal, the disputes tribunal, or otherwise. And, so to that extent, it's quite different. But the Court of Appeal noted at paragraph 30, and I've set the text out, that the reason for that is not an attempt to exclude the jurisdiction of the High Court. It rather requires that challenges to decisions made under the Act concerning rights to compensation be brought under a prescribed procedure involving an initial statutory review, which can be followed by an appeal on the merits to the District Court. And but despite all that, picking it up at the bottom of the page, starting about 15 lines up, the Court of Appeal noted that that specific provision in the 1998 Act overrides the general indication in Section 4 of the Judiciary Amendment Act that relief may be granted on an application for judicial review, notwithstanding any right of appeal possessed by the applicant. And then at paragraph 32, which is the last 10 lines, at times, however, a challenge to the lawfulness of the decision of the statutory authority or tribunal will not be amenable to a statutory appellate process and can only be effectively addressed through that of judicial review by the High Court. That will often be the case where it is alleged there has been a breach of natural justice duties going to the validity of the decision. In such cases, if a privative provision is read as excluding judicial review, there may be no basis for a challenge to the lawfulness of the particular decision-making process at all. The courts will then approach the interpretation of the privative provision on the basis that in the absence of clear language from Parliament, it was not intended to exclude judicial review of particular decisions that did not fall within the scope of the statutory appeal process. So in the last part of paragraph 33, the court proceeded on the basis that it will accordingly be sufficient in the present case for the appellant to maintain its judicial review proceeding if he can show that the grounds on which he relies in seeking judicial review remedies could not be determined under the statutory process. But if they are amenable to decision under the statutory scheme, the effect of section 1 through 4, subsection 4, is the court is barred from granting relief in the separate proceedings. And in that case, the court concluded that the appeal statutory process covered all the pleaded grounds in the review, and so it was otiose to file the judicial review proceeding. Now, turning to another topic, at page 127, the minority in Tanadas talked of the constitutional dimension, because really Section 4 of the Judiciary Amendment Act is all about access to the courts for justice. And obviously, when there is a statutory appeal process, that is accommodated for. And I won't take you on or through the text of that at page 33, but I want to pick it up at page 34. In the extract in the text, The minority noted, and I'm reading from the top of page 34, in the context of rights of appeal and their effect on claims of breach of rights to natural justice, as an Australian leading text on judicial review argues, and that text is Aronson, Dyer and Groves, which was in footnote 6 of the decision, but it was the 4th edition, and I'll come to the 5th edition in a minute. If there is an appeal on the merits by way of a de novo hearing to a person who is unlikely to be influenced by what occurred at first instance, the appeal may be able to provide all that procedural fairness requires. If so, it is a far superior remedy for breach of natural justice than judicial review, since it will not only redress the initial unfairness more effectively and quickly than judicial review can, but also replace the initial decision with a fresh decision on the merits. This provides a strong justification for courts allowing such appeals to cure defects and requesting those complaining of breach of natural justice to exercise their rights of appeal instead of seeking judicial review. Now, translating that to the context of this decision, we've got 6 weeks of valuable judicial review time set down in this court. Now, that there may be a spare week at the end, and Your Honour indicated at the pre-trial conference that 2 weeks have been set aside for judgment writing time, so that's nearly 2 months of valuable judicial resource. And in terms of applying the proviso and the steps of going through, Your Honour has to answer the questions in the case stated, but Your Honour's analysis and reasoning is going to cure or be curative of any defects in the original district court decision. So it's authority there for that, and approved by the minority, and I don't think that would be disputed by the majority. Their dispute was elsewhere in terms of the privative clauses in the income tax legislation. Now, in paragraph 1 to 8 of the submissions, I've made a reference to the 5th edition of the same text, only this time it's now only authorised by Aronson and Groves. And if I could take Your Honour to US case 209 at page 5556 in the authorities, in the US authorities.
Yeah.
And so this is the equivalent section, and I'm at 5558 in the 5th edition, which deals with the effect of rights of appeal. And in the last 3 lines on that page before the footnotes, the authors considering the effect of appeal rights in relation to the requirements of natural justice. And they refer to 2 arguments being made for this. One is that the presence of a right of appeal indicates a legislative intention to exclude natural justice. The other focuses on the potential of a full right of appeal on the merits to overcome any unfairness in the initial decision. And turning over the page, a full right of appeal could meet the requirements of procedural fairness by providing a fair hearing, and also provide a better remedy than judicial review by providing a new decision and usually also a quicker process. The quicker process in the context of the present decision also means moving forward for the parties rather than having to go back to the district court to do it all again, which my respectful submission is a waste of valuable judicial resource. And just dropping down a few lines, the idea that a right of appeal, no matter how full, might provide evidence of a legislative intention to exclude natural justice is now untenable, and that's not what I'm contending for. It's just that the right of appeal will be curative of the defects in the original hearing. Now, just moving over to page 5560, and there's a heading significance of the nature of the appeal. I just want to deal with the 5 lines above that. The authors conclude on this issue, it may be that the treatment of appeals as providing an exclusive remedy for breach of natural justice is best viewed as a particular application of the more general discretion of the courts to refuse a remedy where an adequate alternative remedy exists. So my learned friend Mr. Illingworth, in his initial submissions of the 22nd of June 2016 in volume 1 at paragraph 196, recognised that that could be an answer to the judicial review, that it wouldn't be considered because an alternative remedy was available, and I've already addressed on the overlap. So in terms of the Australian authorities, that's how they would compartmentalise it rather than the more strict approach intended by our Supreme Court. Now, turning to paragraph 129 of the submissions, I've referred to a more recent case. I don't need to take Your Honour to it. It involved a cancellation of a bond licence, in the sense allowing liquor wholesalers to move their stock around between bonded warehouses. And this particular bondholder had his licence cancelled without notice. The statutory procedure provided for review and then appeal, and the court applied both Harley and Preston in the references I've given. That's the latest, most recent authority I can find that deals with Harley and Preston, still showing that those principles are good law. Turning to another topic at paragraph 130, I note that there's always cases where the primary rule is departed because of the point not being taken, or the amount of judicial time already invested in a judicial review before the court became aware of duplication of issues in an appeal. And paragraph 131, the minority in Tannadice referred to Miller and the Commissioner of Inland Revenue being a judicial review of the Commissioner's assessment that proceeded all the way to the Privy Council. And the Privy Council noted in the course of that decision, it will only be in exceptional cases that judicial review should be granted where the challenges can be addressed in the statutory objection procedure. Such exceptional circumstances may arise, most typically where there is abuse of power. Harley Developments Inc. and the Commissioner of Inland Revenue at 736. but they have also been held to arise where the error of law claimed as fatal to the exercise of statutory power and where it would be wasteful to require recourse to the objection procedure. And there's reference to Golden Bay Cement at page 671. Now, the Chief Justice was actually sitting on the Privy Council in the hearing of that judicial review appeal, and the further exception noted there by the Privy Council about a fatal error of law, or an error of law that's fatal to the exercise of the statutory power, was noted in Golden Bay as being an example from the Lloyd Banks case. And if Your Honour needs, that's at page 5091. But the issue in that case was statute bar. So generally, with a few provisos, which didn't apply in the Lloyd Bank case, the Commissioner is limited to making an assessment within a 4-year period. None of the provisos applied. The assessment was outside the 4-year period. So Lloyds Bank filed judicial review to argue that particular point. It could have also been covered by the statutory process, but that would have required a lot of work on other issues, that just weren't going to be relevant because it was black and white. So it's probably only an exception that arises in technical issues like tax. And in paragraph 132, a bit of self-justification on my part, excusing why that judicial review got all the way to the Privy Council, contrary to the position that I'm advocating to Your Honour. In the High Court, the plaintiffs had been put to an election by Justice Barry Gwyneth. I've given Your Honour the decision. And Justice Barry Gwyneth had already spent judicial time on the judicial review and was not aware that there had been a statutory a determination made in the Taxation Review Authority dealing with the merits of the Commissioner's assessment. It is honour noted that during the period of adjournment between the first and second parts of argument in this proceeding, I was supplied by the first plaintiffs points on appeal to this court from the decision of the Taxation Review Authority. There is such overlap between them and the issues on the present application that I put Mr. Grierson to election whether the issues on the application for review should be dealt with at this stage or on the subsequent appeal. He opted for the former, namely he wanted the judicial review to decide the issues. Then Justice Barry Gwyneth continued, I decided that the investment of judicial time and effort to date made it imperative that I should proceed to judgment on all issues unless it appeared more convenient to defer any specific aspect to the hearing of the appeal. So again, and if Your Honour looks at the pages either side of that text, you can see even from the index to the decision, there's 2 pages of index covering the issues covered by the judicial review, and His Honour was well down the track. So again, the election explains why it got to the Privy Council, but one of the reasons for adopting the election was the amount of judicial time invested into the hearing and the need to move it forward. The next topic is the strikeout applications. I don't propose to take Your Honour to them. They can be taken as read. They were filed well before the hearing, so they were, Your Honour's gone well down the track to recognise the issues now. And The second to last topic I wish to draw your honour's attention to is the Russell bias cases. And if I can explain the relevance of these, the paragraph 135, it's respectfully submitted that if Your Honour reaches a position that the finding of extradition offences was a matter of legal submission alone, and that there were no effective challenges to the presumptive reliability of the record of case and supplementary records, then we have a large body of evidence to consider for the committal of trial exercise, which is basically, by virtue of the statutory language and having arrived at that position, undisputed evidence. And then it's a matter of submission whether the prima facie case test is met in relation to the extradition offences. Now, in the Russell bias cases, Mr. Russell had done far too many for me to remember, but the client templates were basically all the same apart from one or two minor differences, but they all involved different taxpayers, and they were done in blocks, and the same authority had done them all. And as I explained yesterday, the issue or the allegation of, or when it came to Mr. Russell's personal assessment, he asked the authority to recuse himself from hearing the personal assessment, which had elements of the same schemes but was quite different because it was personal to Mr. Russell. And the initial hearings refused the judicial reviews, and the first one was on an appeal to Justice Cooper in this court. But when we came to deal with the appeal in the High Court before Justice Wiley, things had condensed to a position that all the facts and contracts that made up the underlying factual matrix were admitted by consent. And so that body of consent evidence, in my respectful submission, is analogous to the body of evidence in the rocks and supplementary rocks. Now, in the Russell case, it didn't stop arguing by way of legal submission. Is there an arrangement? Is it a tax avoidance arrangement? And what should the amount of reconstruction be? So all those submissions were still open. And in this particular case, the same submissions are open in relation to the extradition offences in terms of the big body of evidence that can no longer be challenged, so it's equivalent to that consent body of evidence. So I won't labour the point, but at the top of page 36, the Supreme Court, in refusing leave on the bias issue, noted it, and I'm just going to quickly read the underlying passages. Paragraph 2 of the judgment: the allegations of bias which were behind the judicial review application were not pursued in the substantive proceedings, which were determined on the basis of facts which were not in dispute. And in paragraph 3, the Court of Appeal acknowledged that there was a basis for Mr. Russell's objection to Judge Barber hearing the case, but did not need to decide whether he should have recused himself because of the view that it took that any basis for challenge had been overtaken by the High Court rehearing of the merits of the challenge to the tax assessment. There was no question of the decision of Justice Wiley, who heard the appeal, being tainted by bias, both because no such allegation was made against that judge and because the facts applied were established by agreement. 4, in making its determination, the Court of Appeal did not regard Mr. Russell as having been stopped from raising the question of bias on judicial review because of his failure to take the point in the substantive challenge. Rather, it came to the conclusion on the merits that the judicial review proceedings went nowhere because of the rehearing on the substantive challenge. And 5, in a case where apparent bias could contaminate further appeal, such as where the Taxation Review Authority had made disputed findings of fact not able to be adequately cured on appeal, judicial review of the decision by the Taxation Review Authority not to recuse himself might well have remained open. So we're not in that disputed facts hearing in my respectful submission. So turning to page 37 and picking it up at paragraph 142, we have agreed that any passage in Judge Dawson's decision can be referred to in the case-stated appeal. The factual findings or non-findings must be accepted for the case-stated appeal, and that the minutes that I referred to earlier in the booklet of Justice Asher had recorded that agreement. So the paragraph 144, in a case where apparent bias could contaminate further appeal, such as where the Taxation Review Authority had made disputed findings of fact not be able to be adequately accrued on appeal, judicial review would have remained open. And 145, I've just said this is not the situation here. We are closer, although not identical, to the Russell situation where the judicial review went nowhere because of the hearing of the case-stated appeal, or at least that was such a significant factor to go against granting any judicial review remedy on grounds of bias. So just to put that in perspective, we've acknowledged that judicial review is an adequate pleading where there are allegations of bias being made, but and bias is denied. But the Russell cases support the proposition that where there are no issues of disputed fact will go to a long way of this appeal being curative. Now, although we've got an appeal by way of case stated on questions of law, given the unique nature of the case, it's pretty close with respect to a hearing de novo, in that all evidence before the district court, and the learned friends have acknowledged that the submissions they're making to Your Honour was the same that were made in the district court. So it's very close to a complete de novo rehearing, but needing to be compartmentalised into questions of law. Now, I've set out the other Russell cases at different levels. I don't need to labour those points. But if I can come to paragraph 150, so the decision tree with respect, Mr. Spring thinks I'm overstating the use of the word tree. He regards it more as a sapling.
A two-page sapling.
But first...
He wouldn't say that if Ms. Hyde was here.
But first, the order that is respectfully submitted to Your Honour is that this court should answer the fundamental questions in the order outlined in paragraphs 87 and 88. That should be the 25th of July 2016 submissions. And paragraph 87 simply posed, was the district court correct to find that first, the offences for which surrender is sought translate to extradition offences under section 24(2)(c), and that would cover the Ortmann 8th question in the case stated and the Dotcom 4th question in the case stated. And then secondly, would that evidence justify the appellant's trial under section 24(2)(d), and that would cover the Ortmann 10th question and the Dotcom 7th question. And then Your Honour would turn to the stay issues. Was the District Court correct to find in relation to the funding stay application that the financial position of the person sought did not prevent a fair hearing? And secondly, proceeding with the hearing would not undermine public confidence in the justice system. And then addressing the same two misconduct stay applications. And then returning to the decision tree, paragraph 150.2, then deal with the remaining case stated questions. 3, if there are errors of law, the court determines whether the proviso applies. 4, if it does not apply, then make the necessary orders. So putting the appellant's case at its highest, if Your Honour determined that stay 1 should have been determined in their favour, Your Honour has the jurisdiction to make an order then that the proceeding should be stayed. And you can do that without recourse to the judicial review. In the 5th stage, if the proviso does apply, then this court declines to reverse or amend the determination in respect of the case stated has been stated. And 6, then move to consider whether allegations of bias predetermination are made out. And finally, even if bias is made out, is this hearing curative of it? So unless Your Honour has any further questions, that completes my submissions.
So can I just ask, just while Mr Ruffin's available, at the foot of page 39 there's reference to section 77(3). Is that supposed to be section 73?
Yeah.
It will be.
Yes, 73. Thank you.
Thank you, Mr. Ruffin.
I'm obliged, Your Honour.
Now, Mr. Illingworth.
Yes, sir. The situation is, sir, that we seek time for our replies, and in terms of that, sir, we'd be hopeful to persuade Your Honour to grant us until 2:15 tomorrow. But there is another issue that we need to deal with, which is the documents issue.
Yes.
And we're wondering if we can discuss that now, sir, to see whether we can agree on a process. It's clear that if Your Honour refuses in the other proceeding, if Your Honour...
Just to interrupt, we're probably in chambers for the purposes of
Yes,
filming.
I'm happy with that.
All right.